Welcome, everybody. Our webinar in New York State DFS Cybersecurity Amendment, what you need to know. We're going to focus on a deep dive for those that we believe and you believe the New York State DFS amendments are applicable to you. And, you know, as you may hopefully know, we do a lot of continuous education that are customer exclusives and out to the general audience. We have one coming up on March 5th, Size Matters, Cybersecurity Strategies for Small Business. And on March 12th, we have our next customer-only webinar, Penetration Testing for Smarties, Why, When, and How to Test. Registration will be out soon for those, and we certainly hope you will always join us. And with that, I'm just going to hand this right over. I believe everybody knows Reg Harnish, CEO of OrbitalFire. Take it away, Reg.
Thanks, Dana. Good to see everyone, and excited to take everyone through this, partially because the complexity of these changes to the amendment have really, I really have to do a ton of research and fact-checking on what my understanding of these things is already. But I have to tell you, there's enough in here where, and enough subtle change and complexity in the deadlines and the timing for the different classes that I spent a lot of time thinking about how we would communicate this in a simple way. However, that said, there is some detail that has been left out of this in the spirit of, brevity to some degree. And also keep in mind that you're all customers. And so with each of you in your next cybersecurity review, we're going to sit with you and talk specifically about how do we see this impacting your program, particularly if you're a non-exempt, limited or full exempt organization. That said, it's going to be information in here for fully exempts, for small businesses, and I'll talk about what that means, as well as standard covered entities for DFS. So hopefully a little bit of everything or something for everyone. And we may have a poll here. So let's start there with this. So have you reported or been reporting on your New York State DFS compliance status prior to this webinar? I'm guessing most of you, they're probably going to get, there is a no. Okay, so we're going to help you through understanding what the changes are, because they've actually spent a lot of time on the accountability of your program, as well as the different types of reporting that are now required to DFS, which go beyond your compliance status on April 15th. So we'll do that. Share results. Okay, I just want to give everyone a sense. 75% have been reporting. I think we have another question.
Yep.
How confident are you in your understanding of the recently adopted amendment? Well, my guess is we won't see too many hundreds here, although it looks, feel like I really understand it. Good. Okay, good. Well, hopefully some of the information that we've already shared prior has helped. But again, there's a lot of detail in here. And even, being steeped in countless mandates and legislation and regulations, I have to say, I feel like New York State did their intent was well-meaning, and whether it was the comment periods, there were several comment periods, as well as the way they've, released this, I think their intent was very good, especially in terms of leniency, or maybe not leniency, but really understanding the extent to which small businesses can operate in this environment. So I'll talk about the expanded exemptions, but despite their intent, I think they really confused a lot of people. Certainly, it took us many passes last year to go through and really to get a sort of a solid foundation of what the changes were. So it's the bottom line. There may be better ways to present this information. We've done our best to simplify and educate, but please keep in mind that we're going to spend time with each of you as DFS and covered entities, what class you're in, to understand what your requirements are and how it's going to impact your program. So let's start with just a couple of quick intro points I think are important. So if you're here, we do have a couple of fully exempts. We do have some new folks. We do have some covered entities, small businesses. So we're really covering the gamut here today. So let me just start from the beginning. This law was established years ago, almost 7 or 8 years ago. And I think some people were happy with it because it was less prescriptive, didn't specify a specific framework and some other things. But the point is, it's been around for a while, and we're now experiencing the Second Amendment. Primary focus is NPI, right? Non-public information, which is basically the way we describe NPI is some kind of personal identifier plus financial information and plus potentially credentials. And so any of those data assets that fall into that category would be considered NPI and thus protected under New York's DFS. Now, NPI is a more global term. So other agencies, like federal agencies like the FTC, GLBA, others, those aren't agencies, those are regulations, but they also focus on NPI, and their definition may be similar, but not exact to New York State. Generally speaking, they're very, very close. So why did it change? Well, we got into a point where, first of all, any legislation that's passed is usually outdated when it's adopted. And that's because it takes a long time for a bill to be introduced, a bill to be adopted, become law, comment periods, things like that. So there's a lot of latency in the process for this type of regulatory mandate. So it invariably experiences decay, where the things, the language, the controls, the threats, all of these things change more quickly than the law can keep up with. And so we need to see, regular updates. However, DFS has made it very, very clear that the main driver of this amendment is underperformance by the industry. Constant, issues with, breaches or security incidents, and generally a feeling that the industry, while they are getting better at cybersecurity, they're not getting better fast enough. And so they also reference, advancing threats and the frequency and the severity or sophistication of some of these, threat actors. So it was really a problem there. Well, then, of course, there's always some politics. So any legislation that's introduced, there are influencers who may not have our best interests in mind, but even legislators themselves, right? They need to introduce bills. There might be a re-election season or whatever. So there's always some politics to this, and of course the sitting legislators want to be able to say that they introduce legislation to protect their constituencies. So there's always some of that, and we're not getting into that here today. So who are the new covered entities? One of the big changes is the introduction of a Class A business. We're not even going to talk about Class A businesses. However, it is clear that DFS is very intent, and a big percentage of the changes are focused on large enterprise. Now, luckily, that isn't any of you, because while an enterprise may have more resources, time, money, and energy to devote to cybersecurity, the reality is that they have an impossible task. Organizations like Capital One or these massive mortgage lenders, it's not possible. So I can tell you, I dealt with enterprise cybersecurity for a decade, and very difficult when you have that many assets, that much complexity, people, networks, deep supply chain, a rich data architecture, leveraging the cloud and wireless. It's just not possible. We call it the Golden Gate syndrome, which is the painters at the Golden Gate. By the time they get to the other end, they have to start over because where they started is already chipping. So these Class A businesses, major carve out, and a lot of the amendment is focused on dealing with these big enterprises. Where we're going to focus are on small businesses. So they have specific small businesses through exemptions and through some factors, which I'll talk about here momentarily. So revenue, employee size, whether or not you have affiliates, things like that. And then, of course, covered entities is everyone else. So if you're not a huge business, if you're not a tiny business or a micro business, you probably fall into the covered entity designation. And we certainly have a bunch of you on the webinar today, and we certainly have a bunch of covered entities as customers. Now, what are some examples of covered entities and small businesses that might be included or might be impacted by the changes? This is them. Really, this hasn't changed. So the total scope of business type or organization type, the ones that are supervised by DFS, that really hasn't changed at all. What's changed is how they segment them in terms of importance as well as required controls. And so, for example, Class A businesses, there are no exemptions, and their deadlines for implementing controls are much tighter or somewhat tighter, whereas a fully exempt organization who might be a subsidiary of another DFS covered entity, their responsibilities now at this point with the amendment is essentially applying for that and getting approved that exemption. They don't even have to report on their compliance status because it's being inherited. Okay, so do I have to comply? The recent changes have made it more complicated to understand if you have to comply, and if you do, what do I have to comply with? And if you do have to comply with things, when do I have to comply? It's very complicated, but the basic is, yes, you have to comply. If you are a supervised entity under DFS, you still have to comply. Now, that said, there's a major cascading flow chart of the why and the what and the when, which we'll talk about. However, in some cases, I mentioned, we have as customers some fully owned or wholly owned subsidiaries of a DFS covered entity through which they inherit their program. So their reporting requirements have now been reduced to almost nothing. Now, they're still conducting risk assessments and doing a lot of the things that are important in cybersecurity, but from a superintendent reporting responsibility, that's completely changed for them. Now, and then there's a maybe, and I threw this in here because honestly, there are some details that may affect, although I would have to say that the exemptions have been pretty clear. So maybe the maybe doesn't apply here, but there have been some changes in terms of your compliance requirements and what those are. So let's jump into those because we've got a lot to cover. First, a few things that have not changed, several of which we're happy with. The first one being it's a risk-based approach. So you'll notice that with New York State DFS, they have not prescribed a specific framework like other mandates have. So for example, manufacturers have NIST 171 and other things. So they leave it up to the covered entity to decide what is your risk and how will you treat that risk appropriately. There are some mandated controls, of course, and that's where the DFS comes in. But in terms of prescribing for you or mandating, or in my opinion, overstepping their responsibilities and telling people what they have to do, what framework they have to adopt, they've left it to this risk-based approach, which we think is very smart because everyone is different. You still have to report annually on April 15th, almost regardless of what class you're in, what exemptions you have. There is some reporting that will be due on April 15th, even if it's to get your exemptions approved. Next point, they must be requested. So that hasn't changed. There's always been exemptions with DFS. They're now expanded. We'll talk about those. And then, of course, there's some basic cybersecurity controls that are required. And we like the ones that they have kept around. And in some ways, they've changed those or maybe expanded or enhanced them. But we like what's been done in the progression here. So there are a few things that have not changed. We're going to break the changes down into these categories. So exemptions, which has changed quite a bit. Operations, which is the security mechanics. So it could be technical, it could be physical, well, there's no physical, but technical or governance, administrative controls. We'll talk about that. Those are all in operations. Reporting. So The communication required of you to the superintendent has changed significantly, as well as accountability, another area where we really like the changes. And it appears that whether it was through the comment period or not, DFS has gotten smart about how do we enforce this best practice, this regulation. And through accountability at each covered entity, I think they've done a good job here, making it more practical, but also more, I don't want to say accountable, but I think they've done a good job modeling this. And of course, we're going to talk through the timeline itself, which again is complicated, and we're going to go through each one of you with each one of you individually, so you don't have to memorize any of this. Okay, let's start with exemptions. So they have expanded the fully exempt class. There's always been a fully exempt, but it was very, very small, very niche business types. So now wholly owned subsidiaries through 19B, inactive organizations, you can claim full exemptions if you were an insurance broker, but let's say you've either dissolved the business or you're no longer actively selling policies. And then this reciprocal jurisdiction reinsurers, which actually breaks down into several other things. I don't even know what that is, but 19G gives those full exemptions in that class, so 19G. Additionally, they've expanded the small business limited exemption, which is 19A. And so most of our customers who fall into the smaller micro size class would be eligible for these limited exemptions. Now, be careful, because the 20 employees, the 7.5 million in gross revenue, and then the 15 in assets, that must include your affiliates. So if you have subsidiaries, if you're using contractors, so there is a little bit of fine print here on this limited exemption. But if you are a simple legal entity, only conducting business internally or through that single entity, and your numbers are less than this, then you are qualified for a limited exemption under 19A. And that means there's a whole bunch of things that you're not required to do. I'm going to end this conversation on an important point, but again, going back to that risk-based approach, we like that. And we think that in particular, small businesses should be allowed to manage their own risk based on their risk tolerance, their assets, and a whole bunch of other things. So again, an intelligent approach to this, but the point being that they've expanded this limited exemption for smaller organizations. Then there's this weird class through 19C, so covered entities that don't interact with NPI, which to me, I couldn't think of a single good example. I'm sure they exist, but I couldn't think of a single example of an organization that interacts with NPI that wouldn't be supervised by DFS already. So I'm not exactly sure what this means, but I wanted to include this for completeness. Let's talk about some of the operational stuff. I think this is one of the places where most of you are probably familiar. I'm going to try and really hit on the changes, because some of these have existed in either the prior amendment or the initially introduced legislation. So risk assessments, which were always required, were required periodically or regularly. And essentially, the mandate left it up to the covered entity to determine what was the planning horizon, or what was the periodicity. Is that a right word? How often did you have to do risk assessments? And now it's specifically, they must be conducted annually at a minimum. Now, if you're a customer of ours, you're already doing this, regardless of whether it's required or not. And so, because there's other good reasons to do risk assessments. But now, in terms of DFS and their jurisdiction, you have to do risk assessments annually. So what that means is understanding your assets, understanding vulnerabilities and threats, comparing that to some kind of control catalog that's been standardized, like NIST or something like that, and then assessing and managing those risks. Penetration testing, a few changes here. One is that they now must be conducted annually at a minimum. Then also, some other fine print must be conducted internally and externally. Now the internal is an addition. So, or I guess perhaps both of them are additions because they never used to specify internal or external or both, one or the other. They just left it up to you to figure out what does a penetration test mean? You know, what's an adequate test of your environment? Now they make it very clear it must be done both internally and externally. And so that will be a change, and certainly for those who are not qualified for a pen testing exemption will be some additional investment on your part or additional time. And then policies must be reviewed annually. Again, the prior amendment left it up to the covered entity to figure out how often policy reviews should be conducted. Now it's got to be done at least once per year. We like this as well because just the way the world goes, in particular smaller businesses who tend to become bigger businesses or medium-sized businesses, a lot changes, right? So it could be your data, maybe you acquire a competitor, you stand up a new location, you inherit a new application. It could be a lot of things. So your risk is always changing. So your policies should always be changing. And that has to be done on an annual basis at a minimum now. Okay, access controls. So a general category, and I see a typo here, unfortunately. So access control is a general category. There's a few things that they're being more specific about. The first is this concept of not last privilege, least privilege. And so producing evidence around least privilege can be a little bit difficult. So for those of you who don't qualify for an exemption on this, there is going to be some work, as well as interacting with or engaging with your asset inventory, which I'll talk about here momentarily. Enforcing least privilege, obviously it's in every cybersecurity best practice, but it's a bit abstract at times. But basically ensuring that no user has privileges or entitlements that they don't absolutely need to get their job done. That's least privilege. The next is privileged account management. So something that's become a hot topic in cybersecurity, but admin or other escalated privilege type accounts, they want to see that those are minimized. And so you can expect that, during assessments or user and account audits, we want to see that there's no extraneous entitlements or privileges, but that there's no extraneous or privileged accounts as well. And then regular audits of this information, which is really a best practice. This is now written into the legislation. Vulnerability management has always been in DFS, part of it, but again, it was a bit vague in terms of what they were expecting of covered entities. Now they're very specific. So at least twice per year, they talk about automated vulnerability management, which was an interesting, the automated part. I'm not sure why they care if it's automated or manual. They do talk about both. So you may have assets that are outside your ability to conduct automated vulnerability scanning and assessment and management on, and for those assets, they must be assessed or evaluated manually. And then, of course, they stitch in this risk-based approach to remediation as well. So if it's a critical vulnerability that's discovered, what they want to see is a time frame within which you will remediate all discovered critical vulnerabilities. So let's say you're scanning your Windows systems and there's a critical vulnerability that's discovered. They want to see that it's patched appropriately. Let's say a week, 2 weeks, 30 days, something like that. Again, going back to this idea that we want you addressing the highest risks first. So that part of it we really like. In addition to training, right? So workforce security has always been part of DFS and a bit lax, actually. I think this is one area where DFS has not kept up with industry best practices. We figured out a long time ago that annual training really just doesn't work, and that regular, smaller, shorter drips of training is really the best way to change security behaviors. But in this case, the DFS has now added social engineering testing to they call it training, we call it testing, but to the workforce security program, you must be training and you must be testing on social engineering. That's required now. Multi-factor, really one of the darlings of the industry, right? We're always talking about this, has been tightened up as well. So now anyone who has access to NPI must endure some type of multi-factor authentication. And I believe that there are some details for certain types, for certain classes of organizations, that they mandate certain types of authentication as qualified or not. So for example, SMS versus an authenticator application on your mobile device. Remote access must have multi-factor in all privilege accounts. So regardless of what you're doing internally for accounts and users that don't interact with NPI, if it's a privileged account, doesn't matter. It needs multi-factor enforced on that account. New. So DFS has always had or discussed the concepts of business continuity and disaster recovery planning and testing, but now they're specifically including incident response testing, which is typically a tabletop, as they have described other types of testing as well. And they are mandating that that be performed annually. So this is a brand new exercise for probably many of you here on the webinar today. Certainly over the last year, incident response tabletops, one of our fastest growing services, but perhaps that's because most of our customers were not doing that. Now DFS requires that those be performed annually. Again, for those of you who don't qualify for an exemption for this specific control, this is an additional investment on your part, time, money, and energy. And then backup and recovery testing. So not just testing the backup, but your ability to recover now must be performed annually. Again, an enhancement to language that existed before. So DFS has always referenced your ability to back up, but now testing must be performed and must be done annually. Really a lot of language and a lot of focus on ransomware in particular, which is interesting because if I ask most of the people on this webinar, and honestly, most of our customers, it's financial fraud that everyone is terrified of right now. And while we aren't necessarily experiencing any decline in ransomware, it's kind of been dwarfed by the amount of money and the frequency of financial fraud, things like wire fraud, direct deposit, fake invoices, things like that. So my point is that the intense focus on ransomware with the amendment is because the amendment is 2 years behind. There's just no way to avoid that given the sort of legislative process. Let's talk about reporting. Two types of reporting. There's what I'll call supervisory reporting and then incident reporting. So a lot of change here. And I think for many of you, this will be the most striking change. And so let me just take you through this. So the first is even events that have material impact to your business must now be reported within 72 hours. What that means is if you have a qualified incident response plan and an incident response capability, and maybe you've been tabletopping and testing it on an annual basis, even if an event doesn't reach the level of an incident, it must be reported within 72 hours if there's a material impact. Now, seen enough of these to know that material impact, the reason it's in quotes is because there's not a single definition for that. And you may need to have someone interpret that for you. And certainly we'll have an opinion, but I'm talking about a legal opinion here about what material impact means to your organization. 72 hours is also fast. You know, anyone who has responded to incidents know that these things can linger in some cases for days, maybe even weeks. I've seen them go on for 18 months. So one area here where I feel like they have maybe overstepped and maybe they're not really sure what they were asking for, is because there's going to be such a flood of reporting on these things if everyone's complying that they're just going to be drinking from a fire hose, so to speak. Next, ransomware incidents. So if your incident is confirmed to be some type of ransomware variant, meaning there's some type of extortion, right? So a hostage taking capacity on your data and then some type of ransom or extortion for that data that needs to be reported within 24 hours. So again, while we understand the intent here, DFS is looking at the greater good and protecting all of our customers and their constituents. I think in general, there shows a real lack of understanding of how these incidents play out, because 24 hours is a very short period of time. And most organizations are knee-deep in response and re-imaging, figuring out, do they have backups? And so to distract a responding victim organization to have to now go fill out forms for DFS that will have generally no meaningful impact on their ability to recover seems like a distraction to me. However, I don't have a great alternative, so it is what it is, I suppose. So 24 hours on ransomware incidents, and then if you make a ransom payment, it also must be reported within 30 days. Again, there has been a lot of chatter from law enforcement communities, regulatory agencies about this idea that no one should be paying a ransom. And that sounds great on paper, but honestly, there are organizations who are in a situation where paying the ransom is possibly their only hope. And we haven't really experienced that ourselves, but we know that they happen. And so to put additional scrutiny on the ransom payment, I think does their covered entities a disservice in some ways, because now there's additional fear and additional consequence for paying a ransom if that's, potentially your only option. So, I think here this is a real philosophical area. Do you pay the ransom or do you not? Everyone has a position, but I think DFS here maybe went a step too far with enforcement here. And similar to speed limit signs, they may not get compliance here for the obvious reasons. Additionally, and possibly one of the biggest impacts here, and I'm going to talk about a flow chart that a customer of ours built because they were confused and they wanted clarity on this, is that your events and incidents, it doesn't matter where they happen. This idea or this concept of material impact means the event or incident could have occurred at an affiliate, like a subsidiary of yours, or at a third-party service provider. So a completely separate legal entity that perhaps you just rely on to do some processing or as part of your supply chain. If they experience an incident that materially impacts your business, despite the fact that it wasn't your incident, and while I'm not necessarily saying that you're not accountable for it, because you can't really outsource accountability, but at a completely separate legal entity, you're now required to report those incidents. I'm going to throw a chart up here because that may sound confusing to many. So this is verbatim, word for word. This is a screenshot of a process flow that a customer of ours came up with, and we thought it was awesome. And we wanted to use that here today because we thought it brought a lot of clarity. But you can see how this works, right? So is it a third party? Are they a vendor or an affiliate? If they are they processing NPI? Because remember, there's that exemption for covered entities that don't interact with NPI. But of course, most of your supply chain in this context is processing or doing something interaction with NPI. Are we required to report to another authority, right? So if you have reporting requirements for a different federal agency or something else, then you automatically have to report it to DFS. And then, is there material impact, right? So now you can kind of, if we're not required to report anywhere else, okay, is there material impact? And then, of course, there's this special carve out for ransomware, because for whatever reason, DFS has been hyper-focused on ransomware, and a lot of the expansion and enhancements of this language has been focused on, starting to address this ransomware issue. But you can see, in most cases, you're going to have to report it to the DFS, even if it's a third party that has experienced an event. And we have seen these, right? So some of the big ones, Mr. Cooper, Fidelity, and there's been a number of others that have occurred just in the couple, really since the amendment was adopted. So our customers have been reporting these things. And again, I have to wonder, is DFS regretting their decision to do this because they are likely overwhelmed by incidents and people reporting the exact same incident over and over, maybe thousands of times. And so we'll see what happens here. Wouldn't surprise me if we saw some clarification on these reporting requirements, just because they're pretty onerous. This is pretty intense, and it's a major change for the way our customers will think about or have to think about reporting incidents. Okay, now supervisory reporting has also been enhanced. There are now specifically 2 forms for most of you that need to be considered as part of your April 15th deadline. The first is if you've gone through your DFS assessment, which in most cases we're doing that work for you. If you are compliant, then there's a certification. And if you are not compliant, there's an acknowledgement. And with the acknowledgement comes some additional responsibilities, because admitting that you are not compliant, of course, begs the question, what is not compliant and when will you be compliant? And so when I get to the next part, we'll talk a little bit more about some of those details. Now, because I know that there's at least 1, maybe 2 fully exempt subsidiaries or affiliates here on the webinar, your requirement is actually relaxed a bit. In this case, you have to claim the exemption and be approved. But at that point, you don't need to submit either of these because you're inheriting your program. That becomes the responsibility of your affiliate, your parent company. So along with that acknowledgement comes this board report, which now must include a remediation plan. So it's not enough any longer to just conduct your assessment and then go about your cybersecurity program. Specifically, DFS wants to know that from that assessment, you're reporting those deficiencies to the board, and that for each one of those deficiencies, there must be a plan. We call it a cybersecurity roadmap, but there's got to be some kind of plan for remediation. Now, this is an area where our process may change internally a bit, because generally speaking, regardless of what assessments we might be providing for you, we're generally limiting our recommendations to, let's say, 5 to 8, because we really want you focused on the highest risk. Like, we take a risk-based approach in everything that we do. Now, we want to see that we may need to include additional deficiencies in that cybersecurity roadmap and in those recommendations so that we can satisfy the remediation plan requirement of that. Okay. Accountability, one of our favorite areas, because we feel like, and I've been in cybersecurity for a minute, and we at times have felt that we care more than our customers, or we care more than the industry. And so part of that has been that, one, the industry has done a terrible job educating, and in particular small businesses, about what cybersecurity is, what is it supposed to do, how can you create an asset, a competitive advantage, cost, all the benefits that come from a well-managed cybersecurity program. We've done a horrible job educating the masses about how this is supposed to work. So we do like that there's been some focus from DFS on elevating visibility to cybersecurity in the organization, and then holding senior individuals or groups accountable for the health of the program. So the first is this, that all of your reporting to the superintendent must be signed by the highest ranking executive and the CISO, right? And in most cases, we are your virtual chief information security officer. So we'll have to have those conversations about whether or not you want us on your reporting. Second is that you must establish a senior governing body. And typically, and I believe it says very specifically, that the CEO has to be part of that governing body. There's mention of fiduciaries, but basically the leadership in your organization, the people that are ultimately accountable and responsible for the health and decision-making there, should be part of this senior governing body. And the senior governing body has some very specific responsibilities. The first is in that body, there should be an understanding of cybersecurity. Now, I don't know what that means, and I'm not sure how we even measure understanding, but there's language specifically that says you better have that governing body should understand cybersecurity related matters. That's the language, those are the words exactly. So we'll have to see what that really means, but I think it's a good thing. In my opinion, I may be biased, but in my opinion, leadership that understands cybersecurity are in a better position to avoid its negative effects. And whether that's ransomware or it's your inability to bid on an RFP because you don't meet basic cybersecurity requirements, or you can't get cyber insurance, or you can't keep your best customer because they're sending you questionnaires. There's a whole bunch of benefits to this. And having that understanding, I think, leads to a more viable, healthy business. Cybersecurity has become foundational to a viable business. And I think leadership that have a familiarity with that do a better job managing. Governing body must hold management accountable. So in this case, management is who's managing the program. And typically that's a CISO, and that would be us in some cases, or someone internally. So there's got to be accountability on the health of the program, the progress. The governing body must also review and approve policies. This is important because the policy states your expectations of the organization and its workforce. And it's one of the highest level governance documents in your entire business. So it should be accurate and complete. Now, most of you have policies that we've developed for you. I won't call them perfect, but I will say that they are standards-based and constantly reviewed for compliance and best practices and things like that. But now, once we implement those policies, it's going to be on all of us to review and approve those policies on an annual basis. And then this is highlighted because I've never seen anything like it. But the senior governing body needs to confirm that the company allocated sufficient resources to cybersecurity to manage its risks. Again, I don't really know what that means, details on the ground. How are we going to apply this? But we generally approve of that intent because oftentimes cybersecurity, whether through, it could be because of 100 things, but oftentimes cybersecurity, is just like this small corner of the IT budget, or it's not budgeted at all, and we'll just deal with it if we have problems, things like that. So ensuring that you have allocated sufficient resources is important, right? It should be part of your strategic plan. It should be proactive. It should be measured and measurable. And to have sufficient resources, again, that will likely be left up to folks with legal interpretations. Does sufficient mean for compliance? Does sufficient mean for continuous improvement, which is something that, of course, we preach to all of our customers, that it's not necessarily about 100% compliance, but rather getting better every year and committing to it. I think this is an interesting and probably very important part of this, because I've never seen any other mandate, any other legislation, any other best practice suggest that someone should be accountable for considering the cybersecurity program an asset that needs to be budgeted for, needs to have dedicated or allocated resources, human resources, time, money, and energy. We've just never seen anything like this. So we'll have to see how this goes. All right, let's quickly go through the timelines. I'm just going to confuse you here. Again, I'll remind everyone that every one of you is going to get a highly tailored plan and a discussion around each one of these things. So don't feel like you have to memorize this. We'll make these slides available, and I think we've done a better job than DFS, but still, it's probably going to be confusing. Let's start with small businesses. So this is those of you who qualify for that 19A exemption, the limited exemption. So you have less than 20 employees, less than 7.5 million in revenue, or you have less than, I think it's 20 million in assets under management. So this is for you. We're going to come back to covered entities, which is probably the majority of our customers. First, the amendment was adopted on November 1st, so it's been operational, and it is the expectation now since last year. December 1st, those expanded incident reporting requirements, the things around ransomware, events, your affiliates that may, or third parties that have materially impacting incidents or events, those have to be reported, and you have been required to report those since December 1st of last year. So for this year, what we're looking at. So obviously the April 15th deadline for reporting, that stays. There are 2 forms now that you need to consider. You're going to file one of those along with your regular registration and updating. On April 29th, excuse me, so 2 weeks after your annual reporting, expanded risk assessment and policies. So this means starting on April 29th, you now need to conduct annual risk assessments. So if you're not currently doing a risk assessment against the DFS requirements or another standard, you're going to have to add that, as well as annual policy review. November 1st of this year, expanded MFA and training requirements. So you'll have to add social engineering testing to your existing workforce security program. And then for multi-factor, remember that remote access, anyone accessing NPI, there's very few exceptions here. All of those accounts and users need to have enforced MFA. Next year, May 1st, this is when the internal reporting requirements are enhanced. So board reporting goes from once per year, I believe, to quarterly. I may have that wrong, but the governing body needs to be in the audience, right? So this governing body that you have to establish needs to be part of that, as well as the CEO. The CEO will be part of that body. Additionally, the access control requirements like least privilege. What else is in there? Regular audits or annual audits, and third one. So those need to be in place May 1st. And then next year, so you have a full year to do enhanced MFA. And then, of course, something I haven't talked about yet is this asset inventory. So for those of you who only deal with NPI, and maybe you're not taking credit cards or you're not dealing with any other type of regulated data asset, if it's just NPI, you need to have an asset inventory of every NPI asset that's in your digital estate, right? This is something that we can, of course, do all that work for you, or most of it. We have templates that we can start from, and we can do a lot of this, a lot of the grunt work for you. But that asset inventory is important, and honestly, most best practices in cybersecurity, step 1 is build your asset inventory. We don't always start there, even though that's really a smart move. So this will strengthen most of your plans. Okay, that's for small businesses. Now for covered entities. So if you do not qualify for those limited exemptions and you're not a Fortune 10,000 covered entity, this is for you. And this is the vast majority of the folks that DFS supervises. So last year, same things as for small businesses, the adoption, and then your reporting requirements changed significantly December 1st of last year. What you're going to see with covered entities is that a lot of first of all, there are more dates, but also they have been accelerated. So you have to do many of these things sooner than small businesses. And you're doing more because you don't qualify for some of those limited exemptions. So April 15th, of course, the annual reporting, the 2 forms that you'll have to consider. April 29th, in addition to risk assessment and policy, you have to, at that point, commit to annual penetration testing, and then biennial, vulnerability management. Now, for many of our customers, we're doing that monthly for you, so you already exceed what's required of you. And then the training and testing, you need to be adding social engineering testing to your workforce security program, and that's for April 29th of this year. Later this year, November 1st, establishing that senior governing body, additional accountability, meaning that when you submit your forms, that your annual forms, they need to be executed by the highest level executive. In addition, your incident response tabletops are now required on November 1st. and then incident response plan requirements as well. So building that plan, testing your testing your capability through a tabletop become effective November 1st of this year. So we've got about, 8 months or so to worry about those. Next year for covered entities, enhanced vulnerability management, which is, adds the manual component, the access control updates that we talked about, so least privilege, audits, and one or two other things. And then additionally, antivirus requirements, which small businesses are actually exempt from. A bit perplexing why antivirus would be a carve out for some of these things. But in 2025, you're going to have additional antivirus requirements. And then November 1 of 2025, the asset inventory and enhanced MFA. Okay, we're going to leave a few minutes for questions here. Again, I'll just remind everyone for the third time that we're going to have a conversation with each of you specifically about your situation. So a couple of final thoughts. The first is this. We know that most organizations are not compliant. Say no one, that may be a bit of an exaggeration, but generally speaking, the organizations that we work with are not 100% compliant. But more importantly, you don't stay 100% compliant. So even if you were 100% on, in October of last year, guess what? You're no longer compliant because things have changed. The regulation has changed. But additionally, your data, your business, your strategic plan, your asset inventory, everything changes. And so compliance, what we're hoping you take away from this is that compliance is really one of those things like personal fitness. It's never done. You never cross that finish line. So even if you're compliant today, you may not be tomorrow. This is really about the pursuit of compliance. And that's the kind of mindset that we really want to think about. Are you still exempt? So you may have been exempt last year and not exempt this year, although that would be a bit strange. But the point is that the exemptions are changing. Don't assume that you are exempt this year. Go back, make sure you understand where these exemptions live. We'll help you interpret those. And if you have any questions, please let us know. We'll help you figure out if you are, and if you are, specifically which ones. Are you fully exempt? Are there limited exemptions? And then talk you through what's still required of you. So annual assessments will be amended. So one of the things that we do for customers is, even though we are providing annual assessments, we will help you amend that scoring up to twice per year. So the initial assessment plus the amendments. So if we say, hey, listen, we're at 62%, but we just decided we're going to start our tabletops in October of this year, so we meet the deadline. We're going to build an incident response plan before that. We will go and update your scores, your compliance scores, so they show up in your cyber blast. We're going to know about them in our cybersecurity review meetings. And obviously then you can report those scores to your organization. Most of you are probably likely part of your senior governing body or someone reporting to the board. So we can help you get those scores updated. We're sure that everyone is probably anxious to get the best score possible. We're going to work with you to help you, and advocate for you, just so that any work that you're doing, you're going to get credit for. Then lastly, please let us know if you have questions, whether they're immediate questions or things that we haven't covered today. In our next cybersecurity review meetings, let's make sure that we talk about this if you have concerns, questions, concerns, or issues. And in addition, while the DFS has expanded and enhanced significantly in some ways, in most cases, we can do much of that, if not all of that work for you. So please let us know how we can help. Even if it's just answering the question or talking about, the timeline, we're here, we are your team. And while I'm not sure everyone has expert answers yet about these amendments, I continue to see conflicting reports from law firms and cybersecurity experts. So there's a little bit of dust to be settled here, But the reality is we hope that you'll come to us and get us involved in that conversation, because in many cases we do have good, verified answers or services that can help as well. All right, Dana, back to you to see if there are any questions.
Reg, thanks so much. And thank you, everyone. As Reg said, you can use our chat, or there's a Q&A button on the Zoom strip. You can use either of those, and we'd be happy to answer anything you have. Now, it's a lot of information to process, right, Reg?
My voice is tired.
Sure. Look at this, you knocked it out of the park. Everybody feels like they've got this under control.
Well, listen, again, we kind of hate the question slide. We don't put anyone on the spot here.
We do have one, Reg. Sorry, real quick. We have one that says, you mentioned enforcement of least privileged. How do you interpret this, and how do we demonstrate?
That's a very good question, and I'm not sure I have a good answer. However, what we know is the concept of least privilege helps us ensure that there are no excess entitlements or privileges on an account or on a user. And so part of that will be possibly some reassessment of role-based access control for you. In most cases, if you're in Office 365 or you're using Salesforce.com or QuickBooks, most of those platforms do an okay job of enforcing role-based access control. But we probably want to have a conversation about, in particular, your privileged users, so admins. Do they have more than they need to do their job? You may be thinking of some acute areas where you have concern, but generally speaking, we want to make sure that no one has a privilege that they don't absolutely need to get their jobs done. Role-based access control can be a real lift for some organizations, especially small, because most people are wearing multiple hats. And so you have lots of overlapping roles that just creates complexity. It's not like Walmart where you do one thing all day long, where it's real easy to define what you need access to and what you should be able to do. Small businesses, especially, lots of the folks here on this webinar, where you are an owner or you're in a senior leadership position where you might be doing sales in the morning and payroll in the afternoon. In those cases, you have lots of roles, and so it does complicate the issue. But generally speaking, we just want to make sure that no one has access to or privileges on things that they don't need. It's really a best practice, and honestly, so many benefits. It's one of the reasons that least privileges really sort of stood the test of time. It's powerful.
Reg, thank you. And the next question is, what is an incident response tabletop?
An incident response tabletop is where you take your plan, your incident response plan, and your incident response team. That's really two teams, your incident management team, your incident response team, and you emulate a common incident, let's say ransomware, financial fraud, a stolen or lost device, maybe a breach, in a safe and controlled environment where it's moderated and facilitated. So you try to make it as hyper realistic as possible, but where you have the opportunity to evaluate how well did our plan help us respond to this? How well educated and trained is our response team to apply the plan? So in a half-day exercise, we typically do this in a half-day on premises, in person, where we take one, maybe two scenarios, and we push you through an emulation of an actual incident. And we work and we prepare for a long time before the tabletop. So as we're going through it, it feels hyper realistic. So we're using your applications and IP addresses and your employee names and things like that. And we're simulating something that is highly likely. And at the end of it, you come out with a whole bunch of benefits. One, everyone that was in that room feels more prepared to respond than they did before they came into that. Two, an improved plan. And so let's say it's more detail in playbooks or better descriptions and guidelines on reporting requirements, or could be anything. And then, of course, a more capable team. And if you do that once per year and you do it effectively, that has really long-lasting residual effects in terms of your muscle memory, in people's ability to go from normal day to response mode immediately without panic or stage fright. And it can be done other ways, but that's sort of the approach that we take to tabletop.
And I think that's a last chance for any questions. Otherwise, you know how to get a hold of us, support@orbitalfire.com, or of course you can get Reg directly at reg@orbitalfire.com. We're always here to help.